suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Well, here's one we prepared earlier. The best lawyer you possibly can get, David Whiting, Melbourne solicitor, who helps you out, takes your calls and advises you on legal matters. Our number is 1300 222 774. A lot of the lines are already gone, but a couple are free, so you can jump in and grab them. David, good morning.
Good morning, Virginia.
We sent you away with a little bit of homework last week.
Yeah, more than I thought. But they were interesting questions.
Black mould.
Denise from Nayora had bought a property, and when they moved in, they found that there was extensive mould.
Horrible story.
That had to have been there before the house was made available for sale. And I referred her to a particular section in the Sale of Land Act, which is in the process of being changed. And it was passed by Parliament in April, but not yet in force.
Oh, hang on, is she falling between two bits of legislation
here?
Well,
sorry, she's got the bad one, right?
Okay,
and the bad one, well, it depends whether you're a vendor or a buyer. If you're selling, you're not allowed fraudulently conceal any material fact about the property that you're selling.
Mm-hmm.
Now, the rule change goes to knowingly, right? So if we go from fraudulently to knowingly. So I'm not doing it for the point of deceiving you. It really creates a positive obligation to tell you everything that you think they need to know. And there's also a proposal for the state government to produce Consumer Affairs to produce a list of things that they think are material. So it won't be conclusive, but at an awfully good start. And the story I gave was about a person who was murdered in a house that was for sale in New South Wales. Yeah. Probably not caught by fraudulently, but definitely caught by knowingly, I would have suggested.
So that means?
That means that from, I would have thought in Denise's case, I'd take it a little bit further, because I would have thought that was an absolute endeavour I would have thought, almost for an improper purpose, to hide a substantial defect in the property. So I'd certainly investigate fraudulently a little bit more.
That's worth a call to a lawyer, that one, isn't
Absolutely.
it? I mean, for such a big purchase.
Yes.
Yeah.
Okay. Now, the other two were tenant-related.
Yes.
The first one was a tenant in a multi-storey building in the city, and his smoke alarm went off in his unit, the fire brigade attended, and also the sprinklers went off in the common areas.
In the hallway.
$38,000 was the bill. Is he liable? My view would be, yes, he was negligent in the management of his flat. I would have thought there's a liability problem there. There is an insurance policy that tenants can take out that deals with that issue, but his argument would, and you've got no right to insist that the owners' corporation rely on their insurance policy.
How are you going to come up with $38,000?
With extraordinary difficulty. There's your deposit on something else.
Yeah, really.
And the last one was Rash from Mentone, and he was on the other side. And he had a tenant who defaulted, and they missed out on 6 months' rent. And the insurance company that he actually mentioned in the call was telling him that in addition to the excess, he had to pay or have deducted from his claim 4 weeks' rent. So the easiest thing to do is go and look at the product disclosure statement for that insurance company and for landlord's insurance. In addition to an excess of $300, you lose 4 weeks' rent. I suppose it's the incentive to get a new tenant in as fast as possible.
Yeah, that's right.
Yeah.
In the scheme of things, 4 weeks' rent, I don't know.
There's a whole lot of people with investment properties that are very finely balanced.
Yes, that's true.
So to lose a month's rent, I've now got to go and find the payment.
I admire their internal fortitude, that they can live their life so finely balanced. I would not be able to sleep at night.
Absolutely. Yeah.
I couldn't do it.
And that's it.
Okay, well, thank you very much.
Yeah.
So it's over to you now, 1300 222 774. Michelle in Wanturna gets the first berth this morning. Hello.
Oh, hello.
Go ahead, Michelle.
Oh, thank you. Thanks, David, for taking my call.
Mm-hmm.
I've recently spent over $10,000 on 2 fences from the same supplier, but one was a Colorbond one and one was a pool fence. I wanted them to match, and I know Colorbond is a tricky thing with matching, but the main fence is a registered trademark one, and the other one is a powder coating company who doesn't match the colour, but on their website they give the name as matching the Colorbond. Oh, no, sorry, I shouldn't use names.
No, we already have, so we're in
I'm
deep.
not
That's fine,
Yes,
it's okay.
we're in deep.
I'm not
Yep.
saying anything wrong about Colorbond.
No, we got it, it's okay.
No.
But the matching powder coating company, call it Colorbond, and that doesn't say it won't be like Colorbond. It won't be the same colour, but it's very, very different in my opinion. And so I'm just devastated because it's been drilled into concrete pavers, and that's like in excess of, it's many, many, many thousands more to even.
So the strong suggestion on the website was that this powder coating would exactly match this kind of Colorbond. Yep.
No, but they use the same name. And legally, I just wanted to know, I mean, the nice man that's installed my fence is a nice family business, a small company business.
Yes.
And then there's a middleman who's his supplier who nominate to take their powder coaters from another multi-million dollar company.
Michelle, as I see the problem is that you have, look, there might be an action for damages which would result in the fence being replaced, but in part it would depend upon exactly the colour, the way it was described by the Colorbond people and the way it was described by the people you bought it from. So
They've got the registered trademark on their colour swatch, which is not true. It can't be.
Then you have an action against. Then you have an action against the manufacturer, Michelle.
Well, the manufacturer. Sorry, which one? The powder coating company that supply the powder to.
Well, let's assume
who run the website.
No, it sort of depends on how far you want to push this. I would push it all the way, but if I manufactured pool fencing. And Virginia bought it from me and installed it with you. But you bought from Virginia, you have an action against Virginia. You also have an action against me as the manufacturer. So you can push it back. You can go back and say, look, you promoted it as colour X and it's not colour X. Is it substantially different or?
Oh, yeah. I mean, I'm probably a fussy customer, but I expected a match because I wasn't warned that it wouldn't be a match. But the man that installed it was like, he's an innocent sort of victim because he just went to get something and called it X. Yep. He said it was colour X. He got colour X. It was on his, his order. They supplied what they supplied.
So did he promote the colour to you, or did you look at someone else's website, saw the colour, saw the description, and told your fence installer that that's the colour I want?
In a normal Colorbond situation, you pick the colour and they'll bring it along. Yep. It's just that the pool fences are done by powder coating, and I wasn't aware it wasn't going to be a close match. I thought it would be a perfect match. And when you spend $5,000 on one and $5,000 on another, I'm just drastically surprised that it is so different, and you can see clearly on photos.
Well, I understand that, but Michelle, you may be able to pick it when they're together, but you might not be able to pick it when they're not together. That might be a difficulty. So you're going to need to be able to persuade someone that the difference is significant, not just that there is a difference.
Michelle, of course, I don't give legal advice, no, would I? But I'm not bad at giving life advice. Can you not just get the fence recoated and repainted to match the other one better?
Same problem. You actually need to remove the fence.
No. You leave it in and coat it where it is.
I think that's totally would defeat the purpose of having a nice new fence because all the plating would chip off. It's just a horrible idea. For me, I couldn't do that. And I can't even, and to be honest, I'm not going to get them to replace it. I just wondered what sort of compensation I could get from a disappointment because
that to me would not be a significant amount of money because you basically bought it for the function, not the colour.
Michelle, we'll have to leave it there, and I guess you've got a bit to chew over maybe going back to the company that runs and maintains that website. Thanks for calling in. Peter in Kew, good morning.
Hello, Peter.
Hello, how are you?
Well.
I'm a bit shocked. I'm a non-smoker.
Yes.
And I drive a car to and from work. I was accused by somebody of dropping a lit cigarette. I'd never do that.
Yes.
In an area that I wasn't. In fact, I have proof that I wasn't. I was sending an email at the time from my laptop at exactly the same moment.
And where was your laptop, Peter?
At home in Kew.
All right, and where were you said to be?
I was said to be in Olympic Boulevard.
Okay.
But as I say, I'm a non-smoker. And
Does someone have photographic evidence of you doing this?
no, they don't. But the way it works is, this extraordinary system is that any member of the public can ring the EPA with impunity and just say, I saw this.
Yeah, that's the process, Peter. But in the event that the matter goes to court, they have to come and give evidence.
I know that.
Yes.
So what's happened is I've gone through the process. I was told I needed to submit a statutory declaration with all of this.
Yes.
And they've doubled down. So first of all, I think it's amazing that a statutory declaration that contains this sort of information that I've just given you is not going to outweigh somebody's unsworn statement. So that suggests to me, first of all, what else could you possibly submit? So in other words, there is no process of review. If I can submit a stat dec that says I have proof...
Well, there is a process for review. It simply hasn't worked in your case. My difficulty would be is that what's going to happen is presumably this matter then goes to court and you seek your costs to be paid.
Well, I've been told I can't get costs, and the minimum fee that I will need to go to court is $5,000.
Well, can I say you can get costs? I don't think you're going to get your $5,000, but you can get costs if you go to the magistrate's court in these circumstances. You write to the EPA and reflectively reflect your stat dec and say, and if the matter goes to court, I'll be seeking costs on an indemnity basis. All right?
Right.
Okay.
So that's the system. The EPA, in fact, encourages dobbing in.
Yes, it does. The system relies on that. So there are means here for Peter to argue against it, right?
Yes.
Okay.
I've been told there aren't.
I disagree, Peter. The answer is there are.
Okay, so how would Peter get this started?
Well, he's already started. It's now up to the EPA to issue the ticket.
Yep.
He then comes along and says, I want to defend this. I want it to go to the magistrate's court. This is why. And there's a High Court case called Dietrich, which comes along and says that if you open up to the prosecution and you say why you haven't committed the offence and why the charge is wrong, and they pursue it, then the answer is there's a claims cost.
Peter, good luck. Rusty in Springvale, good morning.
Good morning, both of you. It's a little two-parter. I'm thinking about installing a front fence, and the council have told me that I have to set back my front fence about, old measurement, about 18 inches from the footpath.
Yes.
Now, I'm a little bit worried. I used to have a property that had a laneway, and we used to have to fence it off one day a year for adverse possession or something.
To prevent people making a claim by adverse possession, yes?
Now, would I have to fence that 1 foot by 65 feet of frontage to make sure that no one else claims it?
I think, Rusty, if someone was to make an adverse possession claim on your property, you would be aware of it. Now, in order to adversely possess it, if it was me, I've got to exclude you from the property for a period of 15 years. Now, surely you'd pick it up sometime during that 15 years.
All right. And
so I don't see that one as an issue. If you let your neighbour put his fence on your property for 15 years, I'd be worried. But if it's the nature strip the footpath is the boundary, and you've got 18 inches of garden followed by a fence.
Now, the other sort of little part to that is that's got to be mowed and all that sort of thing. But with the nature strip, if I'm mowing my nature strip and I got injured on it, or my mowing of it broke a part of a car or something like that,
yes.
Would my insurance company cover me whilst I'm doing work on a property which is not mine, i.e.
You would need to look, Rusty, at your insurance policy and see whether you've got any cover, including public liability, while you're on the nature strip.
Or mow that nature strip very, very carefully, Rusty, would be my suggestion.
Which you would, in theory, do anyway.
I would imagine. Yeah. Good on you, Rusty.
Thank you.
Philip in Yarra Glen, good morning.
Good morning to both of you. My problem, David, concerns a recently subdivided property into 2 lots. We live currently on Lot 1, and Lot 2 is where we were intending to build another home, more conducive to our life at the stage at the moment.
Mm-hmm.
The difficulty has been that we originally got a building envelope which provided plenty of space for us to build, but now we find, having had 2 lots of arborists, one about 5 or 6 years ago, and the current one, the latest one 4 weeks ago, he's presented a report that basically makes the building envelope almost unusable because of trees that were planted by neighbours 30 years ago and have now long since left the area.
What's the desired outcome, Philip?
The desired outcome, David, is that I have a big enough building envelope left to be able to build a house that actually has some meaningful space.
Yeah, okay. So my first question is, does the building envelope appear on the plan of subdivision or under a Section 173 agreement?
Unfortunately, while it appears on the plan of subdivision, it's subject to a 173 agreement.
Then what you do is you get the council to agree to an amendment of the building envelope.
Okay, except that this particular council is very heavily into...
Murrindindi, isn't it?
No.
No?
No, come a bit further closer to Melbourne, David.
Yarra Ranges?
Yeah, what a surprise.
Okay.
So...
No, Philip, what they did was, when they registered the plan of subdivision, they allowed you a building envelope.
Yes.
Your argument when you go back to council is, you gave me a building envelope I can't use.
Yeah.
So I want a building envelope I can use.
Okay, so that'll have to go through town planning then.
It will. It'll be an application to, you'll need to cancel and redo the Section 173 agreement, and you'll need to amend the plan of subdivision.
Okay, thank you. I mean, the situation
Good luck.
is... Well, thank you, but just very quickly.
Yes, quickly.
One specific tree, even the arborist pointed out that it's in poor condition, but it's the very tree that has the biggest tree protection zone.
Yes.
And is making the system...
Well, then if there's a tree protection zone, it either arises under the planning scheme or a local law.
All right.
Now,
So
one could come along and say, well, the tree was clearly in place when the plan of subdivision you're talking about was registered. So it's an issue that might have been properly addressed by your surveyor or planner at that stage.
Okay, good on you, Philip. Good luck with it. Let us know how it goes. Barbara in St Kilda, good morning.
Oh, good morning. I'm ringing regarding a commercial premises. We've got 2 car parks on title, and the title goes quite to the rear with an easement at the back to allow access to the adjacent commercial premises.
Yes.
The issue is we have someone parking over the driveway in the adjacent premises, and so I sought clarification from council, who provided the title and said we both have to allow each other access, which is fine. So in the letter from the council, they said it's not a police matter because it's on private property, and it's also not a council matter, and they say it's a legal matter. So my question really is, how is it a legal matter, and how can I address it to get them
Well,
to move their cars?
it's either a contract matter or it's a matter that arises under a plan of subdivision. You see lots of them in the old suburbs where there's a shared driveway that might be 10 feet wide and there's 5 feet on each title.
Yes.
And at the end, the driveways branch, one to the left and one to the right.
At the end of the driveway is the railway line. There's just 2 properties beside the railway line and then from the street.
Okay. Then the issue might be, well, I suppose it's an exercise in mutually assured destruction. They park in the driveway, you park on the driveway.
Yeah, well, this is what's happening, but we park earlier than them, and then people need to leave to pick up the kids from childcare, and they won't move their car.
Right,
and
but
nothing's working.
Then park at the road end of the easement. I'm not saying that you've got
to their property.
Well, it's the same issue, is it not?
It is the same issue. I just didn't want to do tit for tat. I just
No,
didn't understand how it's a legal thing,
well, I'm sorry. You can go off to the magistrates' court and get an injunction.
Yes.
And I'm just thinking, I'm spending thousands of dollars.
Yes.
It just might be, well, here's the issue. If you want to park there, I have the same rights to you to park there.
Not so much tit for tat, but maybe just making the point in a concrete way, and then maybe you can come together and figure it out.
the point's been made with eggs thrown and cars damaged. It's getting quite nasty.
Well,
so
that's
I'm
not the way
trying
to do it.
Yeah,
Then
so
the
I'm trying
answer-
to go the legal option so no one else gets injured, that's all. But
Then the answer might be the injunction, but why not do things like put up some cameras?
we have got cameras, yep.
Well, the
Yeah,
cameras
so
are
I've
the
got
evidence of the
yeah.
breach, and you can get an injunction to make sure that the easement that allows them to pass doesn't allow them to stand.
Oh, okay. So if we have evidence and we do end up going for injunction at the magistrate court, we would provide photographic evidence of the breach.
Yes.
That's the legal answer I needed. Thank you.
All right, pleasure.
Good on you, Barbara.
Thank you very much.
Good luck. My goodness, shared properties and shared driveways. Ay, ay, ay.
Dealing with other people, that's the problem.
Other people, yes. And speaking of other people, lots of comments this morning on text,
Yes.
David, about the matter concerning the pool fence. And dear listener, I just don't think it's nice in a segment like this on other people's legal problems to immediately come back with the old first world problem criticism. Yes, of course they are. This is where we are lucky enough to live, in the first world. How fortunate are we? So it follows logically that I guess by comparison those problems might be first world, but really it is this person's problem in this moment of time.
Yes,
And we take it seriously with David, correct?
I hope to.
Yeah, we don't spend the entire show on it, but we do spend a minute or two on it. So come on, show some compassion, people. All right, who have we got here? Richard in South Morang, I think. Is that right? Good morning. Hello.
That's right, Virginia.
Fire
How are you,
away.
David. Look, we've just recently moved into a rental premises and not knowing at the time, it doesn't have a tap in the backyard. And it's a freestanding home with a backyard.
Yes.
Is that a requirement, David?
I don't know. I wouldn't have thought so, but gee whiz, that's a nice research point, isn't it? So if
Can't
you can,
believe it. Can't
We're taking
grow
that
anything.
I'm taking that one on notice. But if
on
you
notice.
So if you can avoid watering the back garden for another week, I'll let you know. We had some rain last night, so
You could take out a watering can in the meantime, and next week, Richard, you have to tune in, and we will have an answer for you. Okay?
Excellent.
Good on you.
Thank
Well
you.
done. Good luck, Carolyn in Hawthorne. Hello.
Oh, hi. Thanks for taking my call.
Pleasure.
I'm pretty sleep deprived, I must say, and this is what the call's regarding. I'm just wondering what the council's obligation is to enforce local laws. It's regarding my neighbour who's installed split system air conditioners that he uses throughout the night for heating.
Yes.
They're only 2 metres away from a whole series of windows on my property, and it's quite audible at night. The guidelines say they're not to be used after 10 p.m. for heating if it's audible in an inhabitable room on an adjacent property.
Yes.
But the local council are just so reluctant to enforce this. The guy's admitted that he does this, says he's a real estate agent, so he's allowed to. They wanted to measure it.
Well, they're new rules just for estate agents, are they?
Yeah, apparently.
Apparently,
And the
okay.
council haven't issued him with any. They wanted an acoustic engineer to measure it after a council health officer came around and said that he could hear it but didn't know where it was coming from,
Yes.
which is apparently quite typical for low-frequency noise. It's hard to localise.
Yep.
So they got an acoustic consultant out.
So council did they?
Yeah, but at the time he came out, I said it's not very loud, and he acknowledged that it was on, but said that it wasn't very loud. And my understanding was he was going to do a baseline measurement and leave the sound meter there for a week to actually measure it, but
Yes.
he's just come for 2 minutes or so and measured it and thinks that's representative.
Then you have to provide the council with evidence. So why don't you find out what it would cost you to rent your own acoustic measuring device to see what the issue is?
But given that it's quite clearly states in the EPI guidelines and the laws,
Well, can we skip guidelines? Guidelines are guidelines. They're not laws.
what about where it comes to the Chief Parliamentary Council endorsing
No,
it?
it's a guideline. If Parliament wanted it to be a law, they would have made it a law. Council have not made it a law.
Okay.
Parliament has not made it a law. They're guidelines, what we think are appropriate behaviour, and they might give you, Carolyn, your own right of action against your neighbour
Yep.
for emitting noise that interferes with the private enjoyment of your property.
And where does this all leave Carolyn then, David?
Well, Carolyn can either provide council with the evidence that they need.
Yep.
I don't know that it's. The problem is that the councils can't slavishly give effect to everybody's respond. They're not your policemen. They're not there to promote your interests as an individual. So, Carolyn, you either provide the evidence, or as part of a council prosecution, or you commence proceedings against the people next door for the unreasonable noise.
Okay, Carolyn?
Can I just ask, what obligation does the council have to actually assess it?
The council has.
Okay.
Your view is that they haven't done it properly. Beg your pardon?
Yeah. Well, clearly they haven't done it according to what's generally accepted as required.
Well, no. They haven't done it the way some people think they should. Now, you could make a complaint to the Ombudsman that they haven't dealt appropriately with your complaint. Mm-hmm. But apart from that, the issue is then you arm the council with the evidence they need to support the prosecution.
All right, good luck, Carolyn. Thanks for calling in. In relation, David, before I let you go, to our poor complainant who's been hit by the EPA with littering, with a cigarette butt even while they don't smoke.
Wasn't there.
And wasn't there. This little suggestion from Alan. I once received... He says this on text. I once received a notice from the EPA for allegedly throwing a lit cigarette from a car. I simply wrote on the notice, "I don't smoke," in bold marker and returned it. And I haven't heard anything since.
Oh, well, that's a positive.
I think that's a
Then you do other things, like you write to Vic Roads and you ask them to hold the security footage.
Of that, yes.
Of Olympic Boulevard between this time and this time.
Yep.
And
make a diary note of where you were.
And you say you require it for evidence, and then you tell the EPA that you've done all of these things, and they need to be aware that they'll be stuck for witness costs.
Although, David, really, a lot in life is solved with the well-applied use of a Sharpie. A good bold marker pen, I find, can actually solve a number of problems.
You're far more aggressive than I thought you were.
How is that aggressive? Yeah. Just a Sharpie. I mean, I'd be using the Sharpie pen.
A fine line barb, not a broad
I'd be using the fat texter on the car that keeps parking in the driveway on a piece of paper stuck under the windscreen is what I'd be writing.
Okay.
And no effing anything.
I'm
but
very
direct,
pleased to hear it.
Direct.
Yes.
David Whiting, thank you so much. A little bit of homework for next week.